The nightmare typically starts like this. You have no money, so you are forced to sign papers requesting a court-appointed attorney. Now, what if I told you some court-appointed attorneys actually work with the district attorney's office to convict you? What if I told you that some court-appointed attorneys get paid by how many defendants they can convict? Now, some of you probably think I'm crazy for even suggesting such a thing. Well, I'm not kidding. It's all too true in many parts of the United States, especially in Maine. Once you sign that document, which is a contract, you are now considered a customer by the district attorney's office. The reality is your court-appointed attorney's job is to help the district attorney convict you. Think about that. There's absolutely no money in it for you to be found innocent. There is, however, money to be made from you being found guilty. The reality is, your court-appointed attorney will only be gaining valuable experience using you to wipe their feet on as they climb the ladder of corruption in a better-paying job. In most circumstances, your court-appointed attorney will be working hand-in-hand with the district attorney to use you as a stepping stone, nothing more. Since you're not a member of the club, ruining your life is no concern to them. Be prepared for the district attorney and your court-appointed attorney to do any of the following. Engage in conduct unworthy of an attorney. Engage in conduct prejudicial to the administration of justice. Fail to employ any reasonable skill and care whatsoever. They may fail to make timely disclosure of the existence of evidence that tends to negate the guilt of the accused, mitigate the degree of the offense, or reduce the punishment. Unfortunately, they all do this. They may suppress evidence that a lawyer had a legal obligation to produce. They may assist the state to violate the rules of criminal procedure and the court's order. And they may employ means that are inconsistent with truth and mislead judges and juries. Attorneys like Charles Helfrich may false claim you have no right to file motions with the court yourself. Only lawyers can. And if you question your lawyer, like him, they may get vindictive and file a motion so you have to get another court-appointed but district attorney-controlled attorney. To most courts, a public defender's job is to defend the public from you. Most lawyers are a master at manipulation and smooth talkers with a silver tongue. And by coincidence, a total master at getting you convicted and not helping you in any way. Be prepared for your court-appointed lawyer to lie and backstab you by default if you are profiled as poor, disabled, or weak. When dealing with crooked lawyers, it is recommended that you document everything in case you decide to file a bar complaint down the road. Document every ethical violation they try to pull. They are trying to get you convicted and a customer slave for life, or what they call cash cows. Most of these court-appointed lawyers will in your face ignore your requests by default. When they talk to you, they are just typically fishing for information. These crooked court-appointed lawyers are always screening you for what you know about their misconduct, so they know how much they can get away with. If you are profiled as stupid, they will pull some very bold, unconstitutional violations, like tell you you are ineligible to have a jury trial. These court-appointed lawyers want you to believe they are doing everything to help you, when in fact they are doing nothing besides collaborating with the district attorney to get you to take a plea bargain instead of a jury trial. In Maine, especially Hancock and Washington counties, it is typical for your court-appointed attorney to conspire with the district attorney to hide or lose evidence that may prove you are innocent of the charges. If they can accidentally lose one piece of evidence that might help you not get convicted, they will. Your court-appointed attorney may continuously ignore requests for viewing evidence the state has against you. Be prepared for your court-appointed attorney to lie about anything and everything. Remember, there is no money for the court from you being innocent, so chances are you will be found guilty. Their job is to convict. the truth of your alleged crime or your rights is of no importance to the court, the district attorney, or your court-appointed lawyer. Only a conviction is what is important to them. If you really need a court-appointed lawyer to supposedly defend you in your case, when you go to one of the crooked courts in Hancock and Washington County, the judge will choose the appropriate lawyer based on how the court has profiled you. For instance, if you're a man and profiled as poor, disabled, weak, or just stupid, the first kangaroo lawyer the judge will pick is Jeffrey Toothaker, Robert Van Horn, Charles Helfrich, or William Blaisdell. All of these lawyers work with the district attorney and are congenital liars. Now, Jeff Toothaker is interesting because he's a real professional. He will do nothing except blow smoke up your ass kind of lawyer. Jeff will tell you whatever he has to get you to believe he is your friend, and it's his job to help you. He's an absolute master at getting you to feel at ease just before your trial. Jeff will say he's going to do this and say that during the trial. And then when you're at the trial, when Jeff is doing nothing about what he said he was going to do, so you may whisper to him in court about this. Jeff's response will be to tell you to shut up. Since his sudden betrayal of your lawyer during trial has caught you totally off guard, the next thing you know, the trial is over and you are convicted. When you are sitting in your jail cell, you may come to realize that the truth of the alleged crime, any evidence that would have helped you at trial, is of absolutely no importance to them. You may also realize that your court-appointed attorney's job was to work with the district attorney to convict you. If you are awaiting trial while sitting in jail, your court-appointed lawyers will most likely lie to you about filing motions you requested. They will continuously not show you evidence the state has against you, and they may even conspire with the district attorney's office to hide evidence that would prove your innocence. This is not uncommon. Your court-appointed lawyer may even conspire with the district attorney to manufacture or edit evidence they have against you. Hancock and Washington counties are famous for doing that. I know this because I have been there, done that, and didn't buy the t-shirt. I would have never believed that they would go so far to gain a conviction, but they will. Now they're looking to make cash cows, people who continuously pay them over and over. You will find yourself automatically getting jail time, probation, and hundreds of dollars in fines and scam fees that will be added on. Which is the goal? You just became their unwilling slave or cash cow. These people are so professional at convicting people, most defendants have no idea until it is long over. Now, a bit of good news is these lawyers have been practicing this type of misconduct so long, most of them, like Jeff Toothaker, doesn't know any other way. They are so used to engaging in misconduct, they will actually set themselves right up if you let them. They've been doing it for so long. One of the dirty tricks that the courts use is called arraignment, which is actually an assessment to figure out how much they can profit from you. And the reality is, a good percentage of lawyers are essentially psychopaths, liars, cheats with no morals to speak of, and they are obsessed with profiteering at any cost. Now, understand what a psychopath is and how they act. The object here is to understand what kind of person you may be dealing with by identifying traits. Once you identify the traits of a person, you will have a better idea on how to deal with them. Psychopaths are superficially charming. Psychopaths tend to make good first impressions on others and often strike observers as remarkably normal. Yet they are self-centered, dishonest, undependable, and at times they engage in behavior for no other apparent reason other than for the sheer fun of it. Jeff Toothaker does this by trying to get defendants convicted for more time than what the state is asking for. He has done this on multiple occasions. These people like this are devoid of guilt, empathy, and love. They have casual and callous interpersonal and romantic relationships. Psychopaths routinely offer excuses for their recklessness and often outrageous actions by placing the blame on others instead. They rarely learn from their mistakes or benefit from negative feedback, and they have difficulty inhibiting their impulses. Lawyers with this psychopathic personality disorder are arrogant and self-centered and feel privileged and entitled. They have a grandiose, exaggerated sense of self-importance, and they are primarily motivated by self-serving goals. They seek power over others and will manipulate, exploit, deceive, con, or otherwise take advantage of others in order to inflict harm or just to achieve their goals. They are callous and have little empathy for others' needs or feelings unless they coincide with their own. They show disregard for the rights, property, or safety of others and experience little or no remorse or guilt if they cause harm or injury to others. They may act aggressively or statistically towards others in their pursuit of their personal agendas and appear to derive pleasure or satisfaction from humiliating, demeaning, dominating, or hurting others. They may also have the capacity for superficial charm and ingration when it suits their purposes. They profess and demonstrate minimal investment in conventional moral principles, and they tend to disavow responsibility for their action and blame others for their own failures and shortcomings. Now, did anybody recognize any of those personality disorders for any lawyers that you have ever met? Now, everybody needs to be aware of what kind of person you are possibly dealing with, so you can deal with them appropriately. If you have identified your lawyer as a psychopath, try these strategies. Keep your emotions in check. Don't show that you're intimidated. Don't buy into their stories. Turn the conversation back on them. And opt for online communication whenever you can. Now, you need to keep your emotions in check no matter how frustrated or upset you may feel. It's important to keep your emotions in check. Losing your cool gives a psychopath more power over you, as they'll see they can manipulate your emotions. Present a calm demeanor at all times. And don't show that you're intimidated. Lawyers often use intimidation to control others. A psychopath may make subtle threats, stand over you while you're talking, or use aggressive language to get you to back down. Assertively stand your ground and report incidents of bullying or harassment to the bar. Don't buy into their stories. Lawyers often use long-winded tales to paint themselves as victims. They often blame other people and refuse to take responsibility for their own wrongdoings. Showing sympathy for them plays into their hand, so keep discussions centered and on facts only. And if appropriate, turn the conversation back on them. Pointing out a lawyer's flaws can be the best way to disarm them. So when a lawyer blames someone else, turn the conversation back on them. Say something like, "Are you doing okay today? I saw how you responded in the court today, and I wondered if you might be stressed out." And also, opt for online communication whenever you can. For one, you have a written record of what they said, and in a 2016 published study in personality and individual differences, found that psychopath lawyers excel at negotiating when they're communicating face-to-face, but online communications make it difficult, if not impossible, for them to charm their way into your head. So consider requesting all communication via email or text message if you can. And with these people, you need to build your mental strength. If you can't escape interaction with a psychopath, it is especially important to work on building your mental muscles. To deal with these people, you need to get active about taking care of yourself and managing your stress levels. It is difficult to stay mentally strong when you're working alongside a toxic lawyer that is trying to convict you the easiest way possible. And then you have to deal with prosecutor misconduct, which is rampant. They think that they have a right to do pretty much anything. And these prosecutors and their advocates say that complete and absolute immunity from civil liability is crucial to the performance of their jobs. They will sit there and argue that self-regulation and professional sanctions from state bar associations, yet there is little evidence that state bar associations are doing anything to police prosecutors, and numerous studies have shown that those who misbehave are rarely, if ever, professionally disciplined. And this is where you can stop crooked lawyers and prosecutors. You can stop them by filing valid bar complaints. Now, they all have a professional license to practice. So if they're violating your rights, you need to attack their license when they violate their own rules of conduct. They will also do everything in their power to prevent you from knowing how to file a valid bar complaint. There are multiple ways for a prosecutor to commit misconduct. Prosecutor malfeasance can take many forms, including abusive investigative practices, threats, and other coercive tactics. They will lie to eyewitnesses, they will participate in forensic fraud, and they will even go so far as to frame the innocent. The most common forms of prosecutorial misconduct are charging a suspect with more offenses than is warranted. If you ever notice that the police will kind of intentionally lie on their report, and the reason they do this is because the prosecutor can now make charges on you based on a statement instead of a fact. They are basing charges on the way an officer worded his complaint. Another common tactic is withholding or delaying the release of evidence. They may deliberately mishandle, mistreat, or even destroy evidence. Hancock and Washington counties are famous for this. They routinely allow witnesses they know or should know are not truthful to testify. The district attorneys in Hancock and Washington County, Maine, will go so far as to tell the police to make up stuff, and the police will get right up on the stand and perjure themselves because nothing is going to happen. They always get away with it. And if you have a defense witness, they will pressure the defense witness not to testify. They will absolutely refuse to let somebody testify if it's going to help you. This is a popular trick. They've been doing it in Hancock and Washington County forever. And then they also go so far as to rely on fraudulent forensic experts. They like to pull this scam on people while they're in jail by saying they're going to give them a psychological evaluation. This psychological evaluation is not done by any sort of medical professional. It is done with some caseworker employed by them. They will literally sit down with what is essentially a children's coloring book with the most ridiculous, retarded questions, and they will have you answer these ridiculous questions. Then the fake professional will twist things around, and the outcome is whatever the prosecutor wants it to be. This is routine. They do it all the time. And then during plea negotiations, they will overstate the strength of the evidence that they have. And they always use this trick. They make statements to the media that are designed to arouse public indignation. Now, what that means is in the newspaper article written on the subject that is controlled by them, they word it in such a way to point guilt at the individual. They do this all the time. Some of these newspapers, like the Ellsworth American, can write entire articles with not one shred of truth in them, except the names of the people involved. They actually will go so far to make false newspaper articles. This is routine in these towns. And then they will make improper or misleading statements to the jury. They do that routine. And your lawyer will fail to report prosecutor misconduct when they discover it. And they always engage in selective prosecution. They will go so far as to conceal evidence that they have, and then they will fail to enforce perjury statutes. This is typical routine behavior in these courts. Prosecutors will also typically make inappropriate comments to jurors and coax witnesses into giving false or misleading testimony. But one of the most pervasive misdeeds prosecutors do is called the Brady Violation, which is the failure to turn over favorable evidence to the defendant. And this is the most common form of misconduct cited by courts in overturning convictions. To get a new trial, however, a defendant must not only show evidence of prosecutorial misconduct, but must also show that without that misconduct, the jury would likely have acquitted. In 2009, a Supreme Court case showed how absurd the logic behind prosecutorial immunity can get. Prosecutors were found to have fabricated evidence to help them convict two innocent men, Terry Harrington and Curtis McGee, who between them spent more than 50 years in prison. Attorneys for the prosecutors, along with the Office of Solicitor General and several states' attorneys, argued they should be immune from any liability. The Deputy Solicitor General even argued to the court that there is no freestanding due process right not to be framed. So who polices prosecutors? Sadly, the answer is no one. One reason is they all operate in secret. When someone makes an allegation that a prosecutor has hidden evidence, or supports perjury, or committed any number of things that violate law and prosecutorial principles, those complaints are not public, and those responses to the complaints are not public. They only become public once the disciplinary committee decides to pursue actions against the attorney. One of the problems with filing complaints is the disciplinary committee, the bar, is made up of their fellow prosecutors from different counties. No conflict of interest there. So when you file a bar complaint, the people making the disciplinary decisions are most likely golfing buddies with the prosecutor or attorney you are filing the complaint about. For a successful bar complaint, you must have absolute documented proof of misconduct, because the disciplinary committee's job is to deem your complaint frivolous. This is why you see few complaints about prosecutors and these crooked lawyers that go through. They're all protecting their own. So you must have clear, precise, and unquestionable evidence of their misconduct to make them discipline these attorneys. Nowadays, innocent people are put in jail for years for crimes they didn't do, except getting trapped in a for-profit business. These prosecutors get away with this misconduct for years because the system is set up to protect them. So if you file a complaint, won't their licenses be taken away? No. Lawyers basically have to murder someone to get their bar license taken away. Any complaint you file may stay on their record as an allegation of misconduct, though. If there are a large number of complaints filed, they may show a pattern of misconduct to the bar committee. Now, civil attorneys file complaints about each other all the time, but defense attorneys rarely, if ever, file a complaint against a state prosecutor. Why? Part of the reason is because defense attorneys are intimidated and are scared to report on prosecutors' misconduct, and the other part of it is they're actually working with the prosecutors. They're trying to turn people into cash cows. So it's important for your defense attorney to have a close relationship with the district attorney. If they have a bad relationship with the district attorney's office, it can make plea deals difficult and slow down the for-profit system. This causes lost revenue for a for-profit court, so this simply cannot happen. Prosecutors routinely withhold evidence that is important because the defense is rarely going to do anything about it. These career prosecutors believe that nobody can touch them. Nobody. And that is a very dangerous thing in a free and open society. The standard is, the prosecutor says to themselves, is this evidence material to the defense? Now, can you imagine such a standard? Here is your adversary, the one trying to put you in jail, deciding whether the evidence is material to your defense. They don't know what your defense is, nor do they care. Prosecutors are the most powerful actors in our society. They decide who gets charged with and what they are charged for. Life and death decisions in some cases. And they themselves, when they violate the law and withhold evidence or even fabricate a case, they cannot be held liable or sued. They have absolute immunity for their official actions. They can intentionally engage in wrongdoing, obtain a conviction, then put the person behind bars for decades, and when caught, there is no lawsuit that can be brought by that individual who just lost a decade or so of their life. So what can we do? It starts with accountability and sanctions for those prosecutors who fail to follow the law. Since the only thing you really can do is file a bar complaint against them, it's pretty much your only option. So if they violate their code of ethics, file a bar complaint against them. Lawyers or prosecutors, they're all lawyers that hold a license. I will tell you from experience that if they get away with this misconduct with you, you will be a target of them forever. Now, why did they do all this? The reality is there's more people counting the beans than growing the beans. And also, the good news is some prosecutors in the United States practice this misconduct on a daily basis. So they are actually all set up for filing a valid bar complaint. You just not have to know how to go about it. Most prosecutors think they have a right to do whatever they wish. So the second they pull any of their misconduct on you, document everything. Then when the time is right and you are a safe distance away from them, you can file a valid bar complaint with the Board of the Overseers of the Bar.